Let's deal with this issue that doesn't appear to ever have a closure in this country. It's been running for almost how many years now? For almost 6 years. And almost every day there's a twist to it. I'm talking about the 51 million unconstitutional payments to Alfred Agbesi Woyome, the businessman. And you know the result of that. Martin Amidu went to the Supreme Court, and the Supreme Court declared that that payment was unconstitutional and ought to be refunded to the state. Now, he took the view that the state was being too slow in the processes of getting that money paid since he obtained the judgment in 2014. So he went to the court, and the court blessed his prayer and gave him the opportunity to, on the 24th of this month, that's next week, it's a Thursday, to speak to Woyome in the witness box, cross-examine him as to his means. What does he have? What does he not have? Who owes him what? What assets does he have that are available that the state can go after to get the money? He got that. But will it happen? I have asked that question now and again. This is what the court had to say eventually, in conclusion. The court said that given the circumstances of this case, the colossal amount of the judgment debt, and the fact that for more than 2 years, no serious effort has been made to levy execution and no execution process is pending in court, I am prepared to offer an opportunity to the plaintiff applicant, that is Martin Amidu, to proceed accordingly to execute the judgment as a party who initiated the action for the benefit of all citizens of Ghana. My liberal approach to Article 2 of the Constitution, 1992, would, in my view, substantially advance the cause of justice in this case. After all, any money that may be realized from the execution is entirely for the Republic of Ghana, and Amidu does not indeed stand to benefit directly from it. And then the court made the order that Mr. Alfred Agbesi Woyome is hereby ordered to appear before me in this court on Thursday, the 24th of November 2016 at 10 a.m. in the forenoon to be examined orally on oath by Amidu as requested. So let's now get to look at the issue and all the matters that have been coming up as far as this case is concerned. And earlier, I referred to one of the judgments. There were 2 judgments, and the very final judgment was in July 2014. The judgment in July 2014, 29th, this is what the court noted, that the facts and bizarre circumstances of this case are enough to provoke our conscience in ensuring that justice is done to the good people of this country, unquote. You have heard Alfred Agbesi Woyome. He says that he's being persecuted by the courts, and this is so wrong. We'll discuss all of that, particularly what Martin Amidu has had to say about this case. I'll start with the Honorable Deputy Attorney General. And I want you to answer the accusation that even is enforced in this ruling of the court about the claim that for more than 2 years, no serious effort has been made to levy execution to get the money. That's exactly what the court is saying. And the general public of this country believes this is the case. Some actually think it's not about no serious effort. It is about the fact that you are just unable to go after the money. That's why we are where we are. What do you say?
Thank you very much, Samson. And first of all, I want to make it very clear that the Attorney General of the Republic has never intended and does not intend to shield Woyome from the payment of this judgment debt. If you go back to the history of this case, you realize that the Attorney General undertook the prosecution of Woyome in the criminal proceedings that were brought before His Lordship Justice Ajit Nassam.
Right.
And it is a matter of public record that we led evidence, made legal arguments for the conviction of Woyome, which legal arguments were rejected by the court. And I remember that I was on this same program arguing that we had done everything that a reasonable prosecutor in our shoes would have done in order to obtain a conviction. That is, in terms of the evidence that we led, the witnesses that we called, including Honorable Osafo Mafo, the former Minister of Finance, who gave very credible evidence against Woyome. And yet the judge came to the conclusion that we had not made a case for his conviction, and then acquitted and discharged him and got him to walk. On this program, I said I had been involved intimately with the process of prosecution, and that I came to the conclusion, watching the judge, that like a sign that was on my former headmaster's table in Notre Dame, okay, that, you know, my mind is made up. Don't confuse me with the facts. That is the perception. That is what I walked away with. Holding a watching brief on behalf of the Attorney General. You remember that when the prosecution was going on, there were times that I would be in court, and there were times that the Attorney General herself would be in court. That was because we wanted to ensure that the right thing was being done. Now, on that day,
briefly,
yes,
that yes, Justice Ajit Nassam may have fallen on Anas's sword, or his own sword, so to speak, and has since been relieved of his job as a justice of the High Court. But it must be said that he has some very fantastic judgments, some of which might stand to benefit you, all of us, particularly when we are facing criminal prosecutions in the court. Please go on.
Thank you very much for that addition. And I remember that on the program which you hosted, my brother Koku Bako and I were on the same page. Koku agreed with me to the hilt that the judge was wrong, and therefore Woyome ought not to have been acquitted and discharged. And I also remember that A. Sankuma was on this program with us. A. Sankuma agreed with the judge that the judge was right in getting Woyome acquitted and discharged. Okay. Now let's fast forward to this, the civil matter. The last judgment of the Supreme Court was in July.
Is Sankuma agreed with the judge on the basis of some of the issues the judge had raised?
That is true.
Including what he suggested to be sloppiness on the part of the prosecution, and what he thought ought to have been the key witnesses that should have been brought to court who were not brought.
Well, and if you do remember, I also argued on this program that the fact that those key witnesses were not called does not necessarily mean that we had not discharged the burden of proving our case beyond reasonable doubt.
Okay.
All right.
Please proceed.
Okay. So let's fast forward to the civil matter. The last judgment of the Supreme Court, as you rightly pointed out, was in July 2014.
Right.
Okay. So July 2016 would be 2 years since the judgment was given. Now, since that time, we have taken credible steps, and it's a matter of public record, that we have issued Ganashi orders. Okay? In other words, we had applied to the court.
Before issuing the Ganashi orders, you had filed writs to seek to recover the money.
Yes, to seek to recover the money.
Okay.
But we had issued for me, I think we should focus on the enforcement steps that we have taken, because that is what, where the false impression is being given that we've gone to sleep on this matter.
All right.
We issued Ganashi orders, okay, and the Ganashi orders were served on banks that held accounts in the name of Alfred Agbesi Woyome, right? One of the banks is ADB, the Agric Development Bank. Today I have so many documents. I think I can safely say that I'll beat Koku.
You will beat Koku. I can assure you.
In terms of
okay, there were 3 bats that were brought in. You can't beat him.
Okay. So basically, I mean, the documents are here just in case. I'm wasting time looking for them.
Okay.
But we issued the Ganashi orders and served them on the banks. The banks complied with the orders, And all the monies that were standing in the name of Alfred Agbesi Woyome were transferred into the account of the Attorney General. Now, people may not know that the Economic and Organized Crime Office, okay, is under, by statute, works under the Attorney General.
That's right.
Okay, it's an agency of the Attorney General's department. And in all of this, we have taken the view that it is better for all the monies from the JIDA payments that we recovered. So, for instance, the RLG payments, the Azuntaba payments, all of them were paid to the account of the EOCO. And there's a very good reason why we do that. The reason we do it is because they have an exhibit account. And you very well know that the exhibit account cannot be Ghana sheet. So in order that we can show that monies have been paid, we don't want to put them in our own account and then a Ghana sheet is placed on the account and then the money is swept. Okay. And subsequently...
Now just briefly, you have used Ghana sheet a number of times here.
Right.
In plain language, what is Ghana sheet?
Okay. In plain language, it is an order directing the court, all right, directed at a third party who has money that is owed to a judgment debtor to pay that money to the judgment creditor. So in this case, the ADB held money on behalf of Woyome and was directed to pay the money to the Attorney General. So we took those monies into our exhibit account with the Economic and Organized Crime Office. Okay. So that is how it works. Apart from the Ghana sheet proceedings that we have instituted, we also attach the properties of Woyome. Okay, for instance, it was being said on social media that he has a house in Trasacco Valley and that the state pretends not to know. But that house is a subject matter of an attachment. We issued an attachment writ, that is, I don't want to use technical terms again, and then the 5A. Right. And then it was served on him. The bailiffs went to the property and attached it. We're about to sell the property when UT Bank filed something that the lawyers call interpreter proceedings in the High Court, basically saying that he had used it as security for a loan and they had a secured interest in the property and therefore we could not proceed to sell it. So we are also in court with the UT Bank and other banks with respect to the real property, the houses that were owned or that stood in the name of Woyome. Now, some of them were in the name of his company. And you know that in company law, for us to be able to say that he actually owns that asset, we have to lift the veil. So ordinarily, we should have taken proceedings to lift the veil in the courts in order that we can go after that property because we think that the asset belongs to him and not the company. And particularly where the monies that were paid to him, the 51 million, was used to purchase that property. If we could, find, but it probably wouldn't even matter in the long run because after all, if it is his property and he is the judgment debtor, we can go after him. So it is not true, as the judge has stated here, that no serious effort has been made to levy execution. Because we filed an affidavit in opposition. And I believe my boss supplied that affidavit in opposition to you, where we detailed all the steps that we have taken in this matter. Okay, that is our affidavit in opposition that was filed in the court on the 9th day of November 2016 in suit number J8/9. The same suit that we are talking about. Now, in that affidavit in opposition, we also attached all the documents relating to the filings in court. I would have thought that if the judge wanted to go down the route that he has gone, he would have referred to our affidavit in opposition and said that, look, you took steps, to apply for garnishee orders. You took steps to, apply for attachment of his real property and so on. But I do not think that these are adequate steps, and give reasons why. Okay, because we are a republic, a constitutional republic, and not a banana republic. And therefore, everything that is said by the courts must conform to the law in existence. Okay? I said something in court which I think was,
One second.
Okay.
You said the judge ought to have referred to your affidavit.
Yes.
Where you have stated the efforts that had been made.
Yes.
Which, as far as you are concerned, were serious.
Yes.
And not as he describes.
Yes.
He did. In page 4 of the judgment,
Yes.
Of the ruling, he says that the first attempt to levy execution from this court was for Ganeshi proceedings, which I granted leave and invited the Ganeshis to appear in court,
Yes.
which they complied.
Yes.
Indeed, it turned out that the amount realized from the Ganeshi proceedings was ridiculously low,
yes.
and below the expectation of the court and the Attorney General themselves.
Yes, that is true. So, and of course, if you look at the monies that were transferred, the highest was $32,000, a little over $32,000. Okay, the lowest was I think 1,326 euros or something to that effect. So yes, the amounts were low, but it wasn't the fault of the Attorney General that the amounts were low. The duty of the Attorney General is to apply for the orders, okay, and to go after the accounts. If we had hit a jackpot and found that 51 million or $55 million dollars or cedis was in the account, that would have been a jackpot, okay? Would have gone to the bank smiling, and everybody wouldn't have had this discussion. But here is the case: the accounts were abysmally low, right? Does that mean that we did not take the step required by law, and that the step was inadequate just because the accounts were low? You cannot fault the Attorney General that the accounts were low. We were not the ones supposed to put money into the account for it to be high. In any case, if you look at the judgment again and you refer to page 4, okay, you go to page 5. He talks about the fact that we applied to orally examine him.
Right.
But he conveniently, if I may say so, without any, intending any disrespect to the judge, left out the fact that we issued, 5A rates from the same court, okay, and we attached properties of Woyome. He also did not mention the fact that there were interpleader proceedings, and I remember distinctly telling the judge in court that part of the delays that that occurred from 2014 to 2016 is because of the interpleader proceedings. There's no way that we'll go, to court and say just because the payment in respect of which we are making a recovery, okay, is an unconstitutional payment, it overrides everyone's interest. Refer to Article 18 of the Constitution, and then Article 20. Okay, the property rights of those banks are guaranteed by the Constitution. So until the court says that their secured interest should be subsumed over, under the interest of the judgment debtor, the judgment creditor being the Attorney General, we cannot proceed, to do any other thing. Okay. Now, so it is grossly unfair for the judge to have said that we haven't made any serious effort. In fact, we have made serious effort. All the court officials, the registrars, the bailiffs, everybody knows that the Attorney General has taken very serious steps in order to levy execution in this matter. But something, there is another point of law that I think was missing from the judgment, and for which I will say that the judgment, the ruling as it is now, was rendered per incurium. It was, it's per incurium in the sense that...
Per incurium means what?
Oh, sorry. It was, it was the failure to refer to certain constitutional and legal provisions, okay, renders the judgment baseless. It doesn't have a legal basis.
Now you will hold on there.
Yes.
And I return to you, and there's a good reason, I suppose all of you understand why I have to stay with him as long as it's necessary. There are a number of questions that he will have to address. Martin Amidu raises a number of them, and many of you have also raised those issues. There have been questions about when the Attorney General went to the court and sought the permission of the court to examine Woyome orally, and that was granted. When that was granted, it went back to the court and said that it was no more interested in, pursuing that process. And the explanation has been that that was because Woyome had made contact and promised he wanted to pay and everything else. Now, there is reference to the Attorney General going to ask for that process to be stopped, discontinued, on a date earlier than the date Woyome wrote to the Attorney General to commit to want to pay the money. Of course, he suggested that he wants to pay 5 million every 4 months or so. Yes, 5 million every 4 months, so that he will finish paying in 2019. He will answer that question that they went to the court on 26th of October. And then Woyome wrote to them on 27th. There is good reason he needs to explain that. Then also the question about the check that was issued, the Access Bank check issued by Woyome to the state, why it was issued in the name of the IOCO rather than the Finance Ministry or the Attorney General. He has attempted to explain that, but not enough. So he will explain further on that. Now, let's quickly do this. Listen briefly to Martin Amidu. He issued a statement, and then after issuing that statement, he actually spoke, recorded the statements and put it out on social media. Let's listen to Martin Amidu and what he has to say.
The people of Ghana should demand to know from government how its Attorney General can, in enforcing the order of the Supreme Court for Woyome to refund the unconstitutional payments made to Woyome to the Republic of Ghana, accept a check of 4 million Ghana cedis drawn by Woyome dated 4th November 2016 in favor of the Economic and Organized Crime Office as part payment of the monies ordered by the court to be refunded. The Attorney General accepted the Economic and Organized Crime Office check from Woyome and gave a receipt acknowledging the payment, quote, as part payment for the judgment debt of Ghana cedis 51,283,483 cedis and 59 pesos, unquote. When the name can accept a check drawn on the Economic and Organized Crime Office, which was not party to the action, as part payment of the refund ordered by the court on 29 July 2014 for the Republic. I say with all the strength at my disposal that a check drawn by Woyome in favor of the Economic and Organized Crime Office, which was not a party to the action or the judgment creditor, cannot be a check in part payment of the unconstitutional monies ordered by the court to be refunded to the Republic. The acceptance of the Economic and Organized Crime Office check by the Attorney General and the deception of the public by the Attorney General that it is part payment for the refund ordered by the court brings into question the competence of the Attorney General and the government in pursuit of the interests of the Republic. The whole scheme appears to have been cooked to defeat my application for leave to examine Woyome orally on oath. In the hurry of the government and Woyome to defeat my application, they could not even cover their tracks with a check drawn on the Ministry of Finance or the Accountant General as custodian of the consolidated fund. The check could also have been drawn on the Registrar of the Supreme Court and paid into the court for the Republic. The foregoing is evidence, if evidence be needed, that the Attorney General and the government are determined to kill the non-refund of the judgment debt as an election issue by cooking up the deceptive check and receipt to allow the status quo to continue. They are forcefully deceiving the electorate that efforts are being made to retrieve the unconstitutional loot by Woyome jointly with Australia Invest, the client of Lita Blue & Co., a law firm in which the Attorney General was a partner. The law firm is also the President's personal lawyer.
Right, so that's Martin Amidu, who went to the court and got this judgment. I remember saying that last week, and it got me into a whole lot of trouble with Omane Buama. Now, let's hear from Nana Kumia. What's your appreciation of everything that's gone on so far? I followed you on social media, and you were also celebrating the fact that Martin Amidu has gotten this ruling in his favor. And in fact, you were calling for a telecast so that the whole nation will get to watch the duel between Martin Amidu and Alfred Woyome.
Samson, you see, the judge said that he wasn't convinced that the government was doing what was necessary to execute the judgment of the Supreme Court.
No serious effort.
No serious effort was being made. That is very true. That is very true. My brother Ayeni may disagree, but that is the view of the judge. Mind you, even in the criminal trial, there were several instances where government will not go to court because they've left one document in the office. And sometimes government is fined by the courts for delaying the process. And when they are fined by the court, they will then go to court to challenge that fine. You know, a Supreme Court judge looked at it and said that this thing is clearly a plan to create loot and share. That is the core of the problem. This whole Woyome payment cannot happen unless there was collusion and connivance. Clearly, major elements in government have been in collusion and connivance with Mr. Woyome. Otherwise, these payments would not happen. I have been a public official before as a member of parliament. You want 500 cedis to support a poor constituent to pay their fees. You need to take a photograph of their home to show that they are poor. You need to get the documents from the school. It goes to AMA, Accra Metropolitan Assembly, take 500 cedis from the MP's Common Fund to pay fees for this person. When it goes to AMA, it goes to budget, it goes to accounts, it goes to finance, it goes to treasury, it goes to chief director, it goes to the mayor. 7 or 6 offices before 500 cedis will be paid to somebody who's poor and needed to pay school fees. 500 cedis. This is the way the system is designed. So when a case like Woyome happens, it cannot happen unless there's collusion. And that is why the judge said in the earlier case, that the criminal case, that the people who turn these payments to Woyome should be here. Because Woyome on his own, there was no way he was going to be able to procure these payments. And that the payments have been made in collusion and connivance with high public officials who should be here themselves. And it was on that basis that a criminal case that the government attempted was thrown away. Mind you, the government itself had gone to court way back 2009. And in September 2009, had procured a judgment that said they should pay only 1/3 of the monies and hold on to 2/3. Yet still, they managed, government officials in collusion with Mr. Woyome managed to go behind all of this and pay all the money. So clearly, there has been collusion and connivance. That is why all the efforts that have been made, nobody believes there is a genuine effort on the part of government to retrieve this money, starting from the criminal prosecutions right up to today.
As far as you are concerned, all of this is a smoke screen.
It's a smoke screen. There's no debate about that. In fact, the judge said so in so many words. When you read in full what the judge said last week, clearly he says it's a smoke screen. And earlier, the Supreme Court in his ruling, one judge in open court had made a comment that this clearly is a smoke screen. It just creates loot and share. And that is why it's taking people outside the government to be fighting for this cause. I mean, we talk about the Ganishi and all of that. The judge made reference to all of those efforts that you are making.
Not all of
well, but he made reference to some of those things that...
Yes, some he did.
Now, even this Ganishi, your own office, Mr. Ayeni's office, has admitted that the procedure was not the best. And that they should have done
very little.
It yielded very little, not that it was not the best.
Well, but your office have said
yes,
that they should have gone for the oral examination before the garnishee.
Yes.
Yes, that's what I'm saying. So you yourself, you've admitted that all kinds of procedures have been engaged in, and those procedures were not the best. So you yourself, you've admitted that your efforts were not the best.
Not exactly. We're taking extra steps.
I'm saying to you,
extra steps, in a serious effort to recover. That's all.
I am saying to you that your own office has said that the procedures that you adopted were not the best, and that before the garnishee,
they were the ones mandated by law, and we took those steps. We realized that the amounts were not adequate, and that is why we took the decision that the oral examination may yield, further results.
So your statement clearly indicated that the oral examination should have gone ahead of the garnishee.
No,
and also
certainly not.
When Mr. Amidu was going,
something you are a lawyer. I mean, when you obtain judgment, do you start by order 46? You don't start with order 46.
So you want me to show you your statement? Yeah, you deny, but you just admitted to the statement.
So no, I haven't admitted what you are referring to.
I would fish it out.
Which one? Which one?
Oh, that's a statement from the Attorney General.
That what?
That the government should have for the oral examination.
You see, we filed a notice.
Let's get something clear. Let's get something clear.
Wait,
Nana, wait. Are you saying the Attorney General has issued a statement on this matter, or that in the affidavit in opposition they suggested what you have said?
Not a statement. I've seen the affidavit in opposition.
Yes,
and it is in the affidavit that you are referring to.
Yes.
Okay. Now, so sorry. Unfortunately, I have read the affidavit over and again before last week's program, and I read over again before today's. I don't think you can find that in any of the paragraphs, except that you are right when you say that they admit by this process that the efforts did not yield sufficiently, and so they needed to go to the court to orally examine him.
Before the garnishee?
No, before, after the garnishee.
After the garnishee.
Right.
Yes. Okay, I would look for my statement and show it to you.
Okay.
Now, the other thing, why is it that when you have withdrawn from the oral examination, after admitting that the oral examination was going to put you in a good step to trace what has happened to the money, and you withdrew from it, and even the dates, there's a problem with the dates, as you, Samson, have admitted that...
I've not admitted it. I've pointed things out that have become issues of debate.
You have indicated that there's a problem with even the date, because all of these things add up. There's a problem with even the dates. But why then did you oppose Amidu when he was going in for the right to orally examine? You see, so all of this trail of incidents show clearly that the government is not interested in getting the money back, and that all of these things that have been done is a small screen. And when you look at the foundation of these payments, the story, the way Woyome just came and said, I'm owed some money, nobody asked to see a contract. He produced one single letter. On the basis of the letter, the government decided that yes, we should pay.
Progress from that to the efforts to retrieve.
The reason why I'm going back to that is that the whole matter is collusion and connivance.
Okay.
So any subsequent effort is just a smoke screen.
Well, like I read to you from the 2014, the last judgment, 2014. That's the 29th July 2014 judgment that Amidu went for a review of the process. The judges had noted that the circumstances surrounding the facts and the circumstances surrounding the payments were bizarre.
Yeah.
So you're right.
Yeah, and you have my conclusion that Justice Enin said very clearly, and you read the whole thing, that no serious effort have been made.
Okay.
And indeed, Mr. Ayeni, if you speak to many Ghanaians, that is the impression that Ghanaians have.
That's right. That's right. Really, and that's why we're looking for the answers. Now, so thank you very much. Hold on there for me. Now let's listen to Alfred Woyome. He had something to say. He organized a press conference yesterday, and he had a lot of things to say. We have cut some portions of it, very relevant to the discussion, for your use. And before that, maybe I should explain here briefly that I've had messages even coming in. For those of you who watched the footage on the day the ruling was given, and you saw Alfred Woyome with me, and some of you asking a lot of questions. Even in the mainline media, it has been reported that he accosted me and said a number of things. I have also heard some of the journalists play back what they recorded, and they appear to have captured the conversation between the two of us. Now, it's this simple, and I don't want to be the news around surrounding him. The case was finished. We were walking out. He came up to me, held me, as you can see there, and then pulled me to a corner. And then he was angry, I admit. He had certain words to express certain words that I do not intend to repeat. But in the end, he felt I had been biased against him from day one. But in the end, I got him to understand that he was wrong. And his lawyer also intervened and got him to understand that he was wrong. So I take the view that the view he held earlier, out of which he issued certain threats at me, he changed them subsequently. So even yesterday, he called me and we spoke. So I think that should end it there. Thank you very much. Now let's hear what Woyome had to say.
Martin has a problem. If he wants to challenge me and everything, he should go to court immediately, and we will ask the court to call the appropriate authorities so that we bring that in and discuss it, because I'm not the one going to discuss it. So Martin is being used by unseen forces as a weapon against innocent people and people who are doing very well, including the President of the Republic of Ghana, and seeking re-election. And in fact, those using Martin are using him against himself. That's why sometimes I feel restrained to either sue him for defamation or anything, because I understand what is the problem of Martin. And I don't want to go on that tangent. So why do you use such a weapon to fight in the political system? That weapon is against himself. It's very inconsistent. Recently, in this very court, he said several things against me, several things against the president, and the judge expunged it. He swore an oath before the Supreme Court, and they expunged it. You know the consequences for that. And people who know about it don't want to even send Martin to jail. I made a check without writing who is meant to, because I was confused as to who should be the recipient. And after a meeting with the Attorney General, in the presence of the Solicitor General and all these people with agreement we signed with the state, in compliance with the judgment of the Supreme Court, I'm talking about the original judgment. And this check, I was told that there is a suspense account with Yoko. And I stated that it is not a criminal issue that I should be paying money to Yoko. And I was told that they will give me a receipt by the Attorney General. But that suspense account is controlled by the Ministry of Finance. Now, if anybody have a problem with a check, why don't you go and ask what are the consolidated? There are people who are collecting money and they will pay it to the state. I have done my duty, and that is it. Now, it is also erroneous to say that after Woyome said he is not going to pay money. No, that is also wrong, and it's not true. I disagree with the Supreme Court judgment, and I will demonstrate that. And that matter is not finished. It has just begun. But we live under a constitution, and we live under the laws of this country. And I will submit, and I have submitted myself to the law. For 5 years, a fellow citizen like yourselves have been treated this way for the crime that I felt that the government of Ghana owes me money, and I started negotiating. I felt that the negotiation was not okay. By constitution, I went to court. I felt that when I went to court, I won my case. After winning my case, I did not take gun on anybody. The court gave an order. And dutiful citizens of this country who may be in charge of government at that time obeyed the order of the court. The money that was paid to me was and is, I believe, my own money. And that money was paid not into account external, because I am not such persons. It was paid into an account in the Republic of Ghana, ADB bank account, an account that is controlled by the Bank of Ghana and by the agencies.
Right, so that's Alfred Agbesi Woyome, the man in the center of all of this controversy, and that was a press conference he held yesterday. Now, I want to hear from Kweku on this. Kweku, you celebrated, and you celebrated with a dance when you heard that the court had granted Amidu's prayer for him to cross-examine Alfred Agbesi Woyome on the 24th.
Yes, I danced.
Your dance has gone viral. It's all over social media.
It was spontaneous, but she who must be obeyed has cautioned me never to repeat that. So I'm not sure it will ever happen again.
Okay.
It was very spontaneous. And that was because last week we were here, we looked at the prospects of this case. And with the limited legal education that I've had left, right, center, I was not really expecting the court to go in that direction. I was only wishing, hoping, and praying. But if I was looking at the bare facts, the little knowledge I had, I thought it would be very, very difficult. And so I was looking for an extraordinary outcome.
That's so.
Yes,
you
an
use those words,
unconventional
extraordinary.
approach, yes. And so when it happened, I just couldn't help it. And I've read the judgment, courtesy you.
The ruling.
Yeah, the ruling, sorry. Yeah, that's a good one. And I can see that there's a certain spirit in there, you know, that the Constitution is a living document. Let it reflect society as it moves. This jurisprudential issues arise there. So I'm okay with it, even though I've heard some lawyers, and they're making very solid arguments. Kweku Azar, for instance, very, very solid, sound arguments here.
Kweku Azar and Justice Ramsay will share bits of what they have to say, which they think that the ruling is wrong, absolutely wrong.
On the surface, they're making very sound, solid arguments. It's unfortunate I cannot be part of their
discussion.
Yes, I'm obviously against what they are saying, but I can see that there's law there, you know. So it's good. But my brother, he made a point about the ruling being baseless. Do I get a hint of a possible review from them? I don't know. Because if it's baseless, and he's speaking for the state and the AG in this case, so maybe perhaps we are going to have the possibility of them testing the soundness of this particular ruling. And so let's see what happens.
Sorry, can you answer that question now? I've heard you say that you're okay with Amidu going forward to retrieve the money.
Yes.
So like you said, are you interested in pursuing anything from the Attorney General's department?
We have taken a principled stance that in as much as we support any effort to recover the money, we also want due process. We think, for instance, that there should have been a reference to Article 88 of the Constitution and the role of the Attorney General in civil proceedings. We also take the view that there should have been a reference to Section 9 of the State Proceedings Act with respect to parties to proceedings and the capacity to bring an action in a civil matter. And therefore, if the judge had cited those provisions and then departed from them or said that there was a rationale for his departure in Article 2, and given very concrete reasons why Article 2, which confers a substantive right to bring an action before the Supreme Court, suddenly can be said to also inferentially, confer a procedural right to enforcement.
The judge said he had combed through the State Proceedings Act 555 and he found no reason why Amidu, particularly construing together with Article 2, ought not be clothed with the power to do this thing in the circumstances of this special case.
Something what the State Proceedings Act does not do is to say that a private party can take the place of the Attorney General in bringing civil proceedings. But it does say that it is only the Attorney General who can take action, in civil proceedings for and against the state. So for him to say that, why didn't he cite Section 9?
Okay, so
and then the question. 88.
So you say you want to keep fidelity to principle.
Yes.
In that regard, what Kweku asked, are you minded as the Attorney General's department to challenge this particular outcome?
We have made a decision not to. And the reason why we have made that decision is not because we don't believe in the legal position that we've taken. It is because it will continue to give the impression that we are standing in the way of the recovery. And then also, we think that even with the grant of the application, there are practical difficulties that will arise, and the court itself will now come to appreciate the practical difficulties. Okay. And Ghanaians will see why this is the wrong road to travel.
Thank you. Now, his answer that they have no intention to go.
When the practical difficulties arise, we would expect the AG department as an agency of state to assist in scaling those practical difficulties. Again, showing the commitment to recover.
The same reluctant AG.
Well,
to do so. Well,
I wonder if the AG will have the luxury of an alternative relative to the commitment to recover.
Right.
Okay.
So
you have a direct answer to your question.
Yes,
Can we move on now?
I'm grateful.
Yes.
I'm grateful, but you know, I'm resisting the temptation to go back to history in terms of dealing with this matter, because I think we've moved quite a lot forward, and we need to be dealing with this particular situation in which we have. But it becomes so difficult when you hear Mr. Woyome talking. It becomes difficult not to do that. I don't know whether his lawyers have been listening to him, but if I were them, I think I would advise him to shut up. It's better, so that everybody can focus on what is happening now. Now, you see, the AG, I have a little problem, and I need to ask these questions. I have, in principle, supported all those actions, however limited they were, in terms of recovery of the AG. I was very excited with the motion to, very, very excited. I fully backed it. So I was disappointed when
they went to discontinue.
They went to discontinue.
We discontinue with liberty.
Yes, but I was still disappointed.
Okay.
I was thinking that, like Martin said the other time, you could leave it, ask for adjournment, and proceed, because it appears the attempt to do oral examination had its own effect. That brought about a 4 million CD thing.
Yeah.
So why take it away with a liberty to return? Why don't you leave it hanging so that it can serve as a catalyst in inducing more installments coming up way? But see, the 4 million came out of an account with a bank.
An Access Bank account.
Access Bank. Was it on the radar of the AG all along? When they were pursuing those garnishee proceedings, all those things and limited small paltry amounts were coming. All this time the AG didn't know about the Access Bank account. That for me is also significant. 2, when the money came from there in the check form, what has the AG done so far? Have they brought that account to under their scrutiny? Because all his accounts were, as he said, brought under their scrutiny of a sort. You see, there's the need for a certain consistency and coherence.
And there's the understanding that Iyoko assisted them to discover some of these things.
Yes, so what happened?
Iyoko didn't get to know about the Access Bank account. That's a question you've asked.
I have a difficulty.
Other people have asked.
I have a difficulty with that.
And I'll be sharing some points there.
I have a difficulty. And that is what is, that also fuels the perception that perhaps the state is being lackadaisical in pursuit of this particular case. I also have difficulty in accepting that the check was issued in the name of Iyoko, in spite of the reasons he's given. I don't get it. It doesn't make sense to me.
One of the reasons he gives, which I am going to get him to explain further, is that the preference to put the money in the exhibit account of Iyoko is to avoid any persons who have suits against the AG or who have judgment debts against the AG to go and garnish the AG's accounts.
Or AG's, the pursuit of judgment debts by the AG's office. So they've sent all those monies into the exhibit account?
Yes.
or
with
all
JIDA?
the monies that we have
JIDA
we have
money,
gained. No, I'm
everything.
not talking JIDA.
Okay.
I'm talking judgment debts.
Because as he says, the exhibit account cannot be garnished.
Yeah, I'm asking a question. The AG has been pursuing other judgment debts. We've made some gains, I'm told.
Recoveries, yes.
Recoveries. Where were those recoveries sent to? The exhibit account
Yes, sir.
of the UCO?
Yes, sir.
I think we have a difficulty there.
I will explain
I
why.
really.
This is the note on which we take a break. And then when we return, there are a number of questions that Dominic will answer. And Felix, you would have to allow for this so that we allow Dominic to speak to most of these issues directly. We'll take a break. Don't go anywhere. We'll come back.